As I understand it, my charge here tonight, aside from eating pizza, is to talk to you about advocacy, in particular oral advocacy, but we'll talk a little bit about briefing as well. At the outset, I would like to invite you to interrupt me with questions. I think it'll be a whole lot more fun for everybody. But I'm here to be of assistance to you and not just to give a speech. So help me help you in learning what it is that you need to know as you embark on this exercise in advocacy. It is kind of daunting when I hear that number that I've heard 6,000 oral arguments. I actually, in a slow afternoon, calculated conservatively that if you took all the briefs that I've read over the past 17 years and piled them one on top of the other, it would be taller than a 42-story building. If I had to do over again and the governor had said on appointing me, "Here, Jack, is your work for the next 17 years," I'm not so sure I would have been quite as enthusiastic as I was at the time. I know one thing is I wouldn't have been wearing glasses all the time as I do now. But in the course of listening to 6,000 oral arguments and reading, I can't count the number of briefs, I've come upon some ideas about this process of advocacy, and so I wanted to share with you a couple of larger thoughts. Again, please interrupt if you have any questions. But it seems to me that when you come into court, you need to remember essentially three things. Whether you're in trial court, appellate court, whether you're arguing a motion, whether you are trying a case to the bench, there are essentially three things that you need to remember. First, remember why you're there. And we'll talk about that, what I mean by that. Remember who your audience is. And third, remember who you are. Each one of those things has some important components to it that we'll talk about. The first is, remember why you're there. When you're in court, you're there for a reason. Is it there to impress a judge? Remember I'm talking about this? Okay. We're talking about the real world. I know there are some slight differences when we're talking about moot court. Yes, you're there to impress the judge, all right, I get that. But put that aside for a second and let me talk about the real world. Are you there to get the judge to remember how good a lawyer you are? You are there, I think, for one reason, and that is to persuade the judge to do something for you, more particularly to persuade the judge to do something for your client. That's why you're there. If you're there in the Court of Appeals, if you're an appellant, your argument is, Judge, the trial court erred. It made a mistake. And what I need to do is persuade you to agree with me the trial court made a mistake, and you and at least one of your colleagues agree and issue opinion that reverses the trial court. That's why you're there. If you're there for any other reason, you're wasting your time and you're wasting the court's time. Okay? Nobody at the end of an oral argument holds up a little scorecard that says, 9.5, right? That's not what it's about. You are there to persuade the court to do something to benefit your client. Everything you're doing is there in service of that objective. You have to remember that. It is not about you. Correct? I know that's really hard, but it's not about you when you are in court. This is advocacy. It's not acting. I remember there was a case in which one of the lawyers came to the podium in the Court of Appeals, and he said, and cleared his voice and said, "Your Honor," he had a very deep voice that I've always wanted and never have unless I have a cold. "Your Honor, I feel rather like Demosthenes standing at the shore of the Aegean with a mouthful of pebbles trying to shout above the roar of the waves." That's really impressive, right? I remember who that lawyer is. I won't name him. He would be just shocked if he knew that I remember. I remember thinking, wow, that guy is really brilliant. I have no idea what his case is about, but I remember he lost it. Not because of that, but maybe because he was spending more time trying to impress us with his knowledge of the classics and with his rhetorical skills than in service of the real objective, which is to get the court to understand the issues before it, understand why the judge needs to do whatever it is you're asking the judge to do. Grant the motion, to sustain the objection, to overrule the objection, to reverse on appeal, to affirm on appeal, whatever it is, it's all in service of that objective. In that regard, probably the most important thing that you can remember is questions are opportunities, they're not traps. I know that's really hard to accept, but it's actually true. Judges ask questions for a reason. They would like to know the answer. Honest to God, I don't spend my evenings trying to figure out ways I can make lawyers hurl from the podium, right? I get no pleasure out of watching people perspire. It's just not what we do. We've got too many cases, frankly. It's too important for us to take the limited amount of time that we have and try to figure out what the right answer is. That's why we're there. We're trying to figure out whether the person who is the appellant or the person who is the respondent is correct. I don't like getting reversed. Okay, it's not as big a deal as it used to be. After the first couple of hundred reversals, you know, you kind of get used to it. But I would really rather be right. And I need the lawyers to help me be right. That's why you're there. You are officers of the court. We'll get to that in a minute when we talk about who you are. But the way that I get help from you is to ask questions. I actually have a case in which I asked a question of the lawyer, and the lawyer held up his hand and said, "Your Honor, just excuse me, just a second. I really have a limited amount of time here, and I've just got an awful lot of material that I'd like to cover. And could you just hang on to your questions for a couple of minutes, and if I don't run out of time, maybe I can get back to them." And there's like a room full of lawyers, and they're all going. And I said, "It's your time, counsel." And imagine what happened in that case, right? The acronym AWOP comes to mind. And for those of you who have worked in the courts, that's affirmed without opinion. It's what every appellant dreads. That is not helpful. That's not helpful to the court. The court is asking a question because it wants to know the answer. You want the judge to be asking questions. I can tell you from experience, the worst thing for an appellant, for an advocate in court, is a cold bench. The worst, most dreadful thing for a lawyer in court is a judge who just sits there and looks at you. I have no idea what's going on. I don't know if he's asleep. I don't know if he agrees with me and doesn't need to ask questions. I don't know if he's already made up my mind that I'm wrong and doesn't care. I don't know. I want to go, you know, like that to make sure that we're at least connecting. It's a terrible thing for an advocate to be in court and have the judge not engage. You want questions. Questions are opportunities. One of the things that I did when I was a lawyer and I got questions was I always answered the question and then asked the judge, "Did that answer your question?" Some of my colleagues in the bench think I'm crazy for doing that, just like asking for trouble. But I wanted that trouble. I want to know, did that answer your question? Because if it didn't, let me take another run at it. Because I'm here to help the judge understand why I'm right. Questions are not something to be feared. Questions are something to be welcomed.